Employee who says, I need some time away from work. Or you're recognizing that the employee probably needs a little time away from work. Okay, that's good for me to know. So we're gonna try to cover a lot in our hour and a half, and here's our overview. We're gonna try to simplify and a little bit oversimplify this tangled web or maze of all the leave laws. And we're going to touch upon what you have to do and what you can do in terms of policy and giving people time away from work. We'll talk a bit about pay and benefits and how that's paid for, administering leaves of absence from the request to leave to return to work, and we'll go through a number of hypotheticals, and I like to leave some time for, and think about this, is that in the category of hypotheticals, I include one of you or more of you saying, well, what if there was a situation like this? Now, we wouldn't be talking about your company because you wouldn't be talking about that publicly. You know, this is not an attorney-client type of situation. We're just chatting. So if you have questions about a what if, let's keep it at that level so we'll all agree that it's a hypothetical. We're not talking about your company, but it may be helpful to you in your work. Fair enough? Yeah. Okay, good. Okay, so let's... So we talked a bit, but we'll go further. Employer size triggers the leave of absence requirements. You know this. Employer policy can trigger leave of absence rights. So we'll go through, there's some things that you just have to do, but most companies have other benefits and other leave opportunities. You'll see in a moment that there's not much legal requirement for you to pay people when they're away. Most of the time when that happens, they're using up their own, if they're out for their own condition, they're using their sick leave accrual, and at their election, they're using vacation or PTO. As a general rule, if somebody wants to be out for their own medical situation, then you can usually require them to use whatever sick leave accrual that they have. As a general rule, because you're all aware, I think, that vacation has just a special place in California, that once it's accrued, it's deemed earned, and if it's deemed earned, it's deemed a wage that you can't take away, so you know this on terminations and exits. That same concept generally applies in most of the leave situations, that you tend to not be able to force somebody to take their vacation accrual, except for FMLA and CFRA. But for just about all the other leaves, you can't really force somebody to use it. Now, most people want to use it because if they're out of work, they want some sort of income replacement. But usually employers, I get this question a lot because they want people to consume the banks of accruals that they have so that they are reduced, because in case somebody may not return to work, there won't be anything to pay them out at the end. So also an overview concept, assume that any time you're required to provide a leave, that some form of anti-retaliation or anti-discrimination law applies. We're not going to identify today where it is, in which statute, but you should always assume that you cannot discriminate or retaliate against somebody because they're exercising a legal right and saying, I need pregnancy disability leave, or I need some other sort of leave that's required by law. Whenever somebody asserts a legal right, you cannot shortchange them, so to speak, or discriminate against them. I mean, this is a fundamental concept in employment law that you don't have to look at the specific statute to know. Assume also that and I didn't put it up here, but assume also that just about every time there is a leave of absence right that's required by law, that there will be a right of reinstatement. One way or another, there are if you're on the front line, you know that there are some nuances. Hopefully you all have employee handbooks and that they're up to date, and if they're not, please don't let me forget to say those should be reviewed by outside HR professional or outside counsel, just to double check to make sure you're getting it right, so you're up to date and your employees are up to date. And is anybody surprised by how much there is here, or somebody sees something and say, I didn't know that there was a requirement for a leave like that? You know, so for example, it doesn't come up much, but crime victims leave to appear as a witness in a court. Now, if somebody came to you, you'd probably do the right thing and say, well, of course you can have some time off to do that. You know, there's something serious going on. I mean, most companies are, they're either good people running it, or they've realized that you need to be good to your people for them to feel good about their work and be at their highest productivity. I find that there are very, very few managers at my clients who aren't wired that way. And maybe I'm just picking clients well, or they're picking me well. But if you start off in a good place, but recognizing that no employer wants to be taken advantage of, these start to make a little more common sense. But there are some companies who just say, I can't believe all the regulation. Like we just heard, there's more regulation, and I'm not sure if I want to be in California. So I want to highlight a few things that don't come up that often. So one is crime victims leave. Another is, how about voting time off? This comes up twice a year, right? Or in some years. And how do you, does anybody know how you pay people? What are the pay rules for voting time off?
2 hours, the same rate of pay.
Right, right. So that's right. And technically it's written as a way that it applies to every employee. But let's touch on one thing and see, and this is a point of confusion. So when I ask a question, don't feel bashful. If you are looking at it one way, I might learn something, and if I'm looking at it if you're looking at it a different way, you might learn something too. So we do the give and take here. So exempt employees and non-exempt employees. There's an overlap into this area. So the easy part is that when non-exempt employees are not at work, they don't get paid, right? That's easy. Now, voting time off is a little different. If the ballot day falls on a day that they're normally scheduled to work, they'll get paid a couple hours to go out and vote, and that's a requirement. But what happens if you have an exempt employee who, certainly in the voting situation, it's not that they get paid 2 hours, but they're going to effectively get paid for the day. And how do you, who's comfortable, if anyone, with the concept of partial day absences or time out of work for exempt employees and how you pay them? Okay.
Well, you identify in the policy that any time away from work has to be deducted or can't go unpaid. With the salaried exempt employee, they need to use available sick, PTO, whatever it is appropriate. If they're out of sick, of course, well, it has nothing to do with sick voting, but you would use your PTO or vacation time.
Okay.
And it's like the first 2 hours is your freebie, and then anything else after that falls into your PTO
All right.
time.
On the voting day, you're saying.
On the voting, right.
So, but what about the situation where, let's take it out of the voting context, what about somebody is out of all paid PTO or sick pay or what have you, and they're not at work at all for that week, an exempt worker.
Well, for the entire week?
Right.
Well, then I could.
Then it's no pay.
Right.
That's really the only time that it's a no pay,
Okay, yeah.
right? And so something for you to consider. It's a side issue for you to jot down. So my firm and a number of our clients have instituted for exempt employees a no accrual vacation policy. And so you need the right kind of professional environment where people will trust that the company's going to be permitting time off. And you need the kind of workers, exempt workers, that understand that they've got a job to do, whether it's client-facing or some sort of supervisory role, and that you can trust them not to abuse that. But the idea is that you can avoid the situation like, so let's say, I'll try you out. So let's say I'm an exempt employee, I work for you, and I think I'm on a vacation day. You think I'm on a vacation day. Normally you deduct it from my bank, and that's how it would go. But I'm on my email, right?
It's great, I actually addressed that. I write the policy saying that if a salaried exempt employee must get executive permission to do it, failure to do so, subjects them to disciplinary action.
Right, so it's a discipline issue, but it's a place where any company could stub their toe. And also, we live in a world where everybody carries their email in their pocket. And I'm seeing more and more, I don't see too many claims, and we'll see there's a hypothetical on this later, I see too many claims on it, but I'm just clarifying for you that if somebody is on their email for work, they're reading, responding, what have you, and they're an exempt employee, they have done some work that day, and I'll say technically, because I hate to just put it out there, but you can't deduct their day. And none of you know when they're emailing. None of you really know, because you're not monitoring them, and most companies, as a practical matter, they don't shut off the email when somebody's away from work, because that seems inconsistent with running a great company. So it's a side issue. When I was thinking about this program, there's so many interconnected issues, but how you deal with exempt employees, and I would not it's safest to only permit use of full day blocks for a PTO or sick or what have you. There's a good argument to be made that a half day block is workable. There's some literature with the labor commissioner that says that can be okay. But smaller blocks, can be a problem, because now you're counting hours in too tight a range, almost like they're a non-exempt worker. So again, it's why I organize. Usually, when you see charts like this, it's usually grouped by the type of leave. And I wanted to create something that was organized by size of company, and this is a place where it will help you. You see that the new parent leave doesn't apply if you're 50 or larger. Why? Because if you're 50 or larger, you already have to do it under FMLA and CFRA. You already have to do it, so you don't have to do it again. Okay? Great.
Can I ask a question?
Sure.
On that 50 to 40, because I'm actually in that range in our company. You still pay your benefits, right, during that period?
If
As
you're,
if it was FMLA?
yes.
Okay.
Yes.
So you just pay your portion, the employer
You
portion
pay
of the
your,
benefits.
right, so for new parent leave and also for FMLA, CFRA, there's no salary continuation required, okay? So it's unpaid leave, subject to whatever banks are available for an employee to draw on. And then for the benefits, and the benefits really medical insurance is the big one, the employer needs to continue to pay at the rate and level that they had prior to the leave. So if you pay 100%, you're going to continue to do that. If you're an 80% pay, you need to do that, and the employee is supposed to make it up.
All right. And then say they don't return after 12 weeks. Mom decides
It happens.
to stay home. So then you send the letter, the same thing that, and then COBRA.
Right, you send COBRA, that triggers, and if they have, it may be in one of the hypotheticals, but I'm going to put it out now, is that you've probably seen instances where somebody's on a FMLA or CFRA leave, or even pregnancy disability leave, or parent leave. All these instances where you need to continue your medical insurance at the same
Montage Insurance. Our mission is to further your mission with dedication, service, and integrity while protecting your assets and giving back to our community.